Okay, welcome everyone. Thank you so much for joining us today for our third Thursday webinar series at MVLS. I know it's been kind of a crazy time with a lot of people working remotely, but we think that this is a great time for people to spend some time working on um, developing professional skills and relationships, but viewing some of our training. So welcome to this training on getting off on the right foot, managing client expectations and relationships. We are very glad to have you. My name is Margaret Henn. I'm the Director of Program Management here at MVLS. And we have with us today Jose Canto of the Canto Law Firm. He is a litigator with a focus on immigration, family law, criminal defense, employment law, estate planning, and civil litigation. And he has been a wonderful member of the MVLS panel since 2012, has taken quite a few of our cases in various areas, including domestic violence, family law, employment, landlord-tenant. We're very glad to have him here today, both to share his experience on kind of managing client relationships, as well as to share a little bit of what his experience has been working with MVLS clients. So Jose, thank you so much for being here. I'll also just mention to the audience before we dive in that the slides that we're going to go through today, there should be a handout section of your webinar screen where the slides are included, so you should be able to download them from there. But if you can't for some reason, they will also be posted on our website, as will a recording of this training. And so you can always download them from there, or you can email me, and I'm happy to send them out to everyone. So we are going to go ahead and dive into our training. With that, I will turn it over to Jose.
Well, good afternoon, everyone. Thank you so much, Ms. Henn, for that introduction. It's a pleasure to be here with fellow volunteers to talk about client interactions, client relationships. And part of the webinar is to try to help each of you as volunteer attorneys identify good clients and also to identify bad clients, because there is a mixed bag of clients out there. And as you're taking on pro bono or judicare cases, you want to look for the right client for you and the right client for your practice. And you don't want to be bogged down with a client that is difficult or unreasonable. And there are ways to triage that, ways to help improve clients and get them to a better place. And maybe you can salvage the attorney-client relationship. But for some clients that are unsavable or that you can't save, it may just be best to not take on the representation and to focus on other clients that might need your assistance, be it private or pro bono. I just wanted to say at the outset that most clients I've worked with through MVLS have been excellent. I can only think of maybe 3 or 4 clients over the last 8 years that I've been working with MVLS that have caused me some difficulty, or were clients that I had to withdraw from the representation. And I've taken on hundreds of cases over the years, so it's a very rare problem to have. But I think it's important that as young attorneys, as volunteer attorneys that are starting to do pro bono work, to try to identify good clients and also identify bad clients as well, to make sure that you're not in a bad situation where you're overly stressed, overly worked up about a case where you could have identified something early on that was a red flag that would have prevented you from having the problem. So if I can move on to the next slide.
Sure.
So I just want to talk about client expectations of you as a lawyer, because clients have a laundry list of expectations for you as their attorney. And also the bar and the ethical committees, they expect you to be professional in your appearance, your punctuality, your respect for the legal system, your respect for people in the system, opposing counsel, opposing parties, your own client. And clients expect you to have 100% effort all the time. There's no shortcuts in litigation. Everything has to be 100% at all times. Clients expect you to listen. They expect you to be there to answer the phone, to listen to their case, to listen to their problems, to listen to their issues, and to be not only listening, but also processing and digesting their information and also applying the law to the facts that they're presenting to you, to give them a very realistic and reasonable approach that can produce results, that can lead to a favorable outcome in our court system. And lastly, clients expect you to be honest. They expect you to always tell them the truth, to always tell the truth to other attorneys in the system, the opposing counsel, a best interest attorney. They expect you to always be honest with the court staff, and especially with the judges. So there's a lot of pressure on us as attorneys to live up to these ideals, which we have to do every single day of our working lives. But I always wonder, why can't we apply these same rules or these same expectations for clients? I think you should be able to expect your clients, be it pro bono or private clients, to be professional, to have a good appearance, to be punctual, to have respect for you and your office staff, and to always give 100% effort in their case. They should also listen to you. They should, if you're going to listen to them, they should also listen to your advice and process your advice and your wisdom as you gain experience as a litigator. And of course, you should expect your clients to be honest. They should give you honest documents, true documents. They should tell you the true story of what happened. They shouldn't hide facts or hide any types of negative issues in their case, because as an attorney, you have to have complete understanding of all the various factors, but sometimes clients don't want to tell you the whole truth, and sometimes they might lie. So the question I posed to each of you this afternoon is, why can't this be a two-way street? It should be a relationship that has equal values by each part, and there shouldn't be unfair, one side shouldn't live up to one ideal and the other side not. And that's why I have this saying here in Spanish. My father's from Puerto Rico, so a lot of my lessons as a kid came through these types of sayings. And this one in particular is relevant to this type of issue. En casa de herrero, cuchillo de palo. And what this means in English is that in the blacksmith house, or in the house of the blacksmith, there are wooden knives. And it kind of makes this point in a creative way by saying, a blacksmith spends his whole day working with iron, with metals, selling metals, and promoting metals. That's part of his job. But then when you go to his own house, he doesn't have any metal. He just has wooden knives. And I use this example when dealing with clients, because sometimes they're going to come into your office expecting you to be professional, expecting you to listen, expecting you to be honest. But the problem is they themselves don't live up to those ideals in their own private lives, in their own house or in their own situation. They're not professional. They don't want to listen, and they don't want to be honest. So when you meet clients that aren't living up to these ideals that you and I have to live up to, this might be a client that you red flag, and maybe you approach them differently, or you may not take on the case because these three issues or these three ideals, if they're not checked off or not satisfied from the beginning of the case, it's just going to get worse. It's much easier when you're in your office, dealing with these issues, because you can easily withdraw from a case by saying, I'm not going to take on the case. But if these issues present themselves at your office, it's just going to get worse as you go through discovery, as you do depositions, as you eventually go to court. And once you get involved with a court case, we all know it's very hard to withdraw from a case. So when you see a client that is lacking one of these three core values that I consider to be core and essential to an attorney-client relationship, you may want to consider not taking on the case if they're not willing to be professional, to listen, and to be honest. And if initially they're not like this, they don't believe in these ideals, you can always coach them. I always say that, as an attorney, you're an advocate, but you're also a counselor. You're supposed to give advice. You're supposed to give them personal advice from time to time that may impact their case. So there is a window to improve. There is a window you can open to try to improve on these things. But after the first couple meetings, if they're not learning or they're not trying to improve, it might be a case that you decide not to take on. So if you're going to be a blacksmith, make sure you have metal knives, is my advice to clients. Next slide, please. So let's talk about some of these three ideals a little bit more. When you have the first initial consultation with your client, what do I mean by professionalism? Well, if your client arrives late, really late, or is a no-show without any explanation, to me, that's a pretty big red flag. I mean, you're a pro bono judicare attorney. You're doing this either for free or for reduced rate. So a client, when they get that letter from MVLS, should be delighted. They should put that letter, on their TV screen or on their window in their bathroom or their mirror in their bathroom, and they should be thinking about this case every single day until they come to your meeting. They should be very excited, and there should be no reason why they're late. They should be there on time or even early. In my experience with MVLS clients, they're so happy to have an attorney help them. They'll be here up to 30 minutes before your meeting just to make sure they're not late. But if they show up late or are no-show and they don't have any explanation, that's a red flag because, like I said, what happens in your office is a microcosm of what's going to happen in court. So if they're not showing up to your office on time, they're arriving late, they're a no-show, they may do that to you in court, and you're going to have egg on your face at that point because if your client's late, if your client's a no-show, the judge is likely going to blame you for that error, and you don't want to be in that position, even though you had no control over that. But that's one red flag that I think reflects on a lack of professionalism. Appearance, clients, I understand clients don't have millions of dollars. They may not be able to afford really expensive clothing, but it's a legal consultation. So clients should come presentable. They should come sober. They should come dressed professionally. Whatever that may be. It could be a collared shirt. But I always look at appearance. How does this person look in my office when they come for a legal consultation? Because how are they going to look in court? With a lot of these cases for divorce and custody, I think the appearance says a lot about character and what type of person they are. So they come in with a tie, they come in with a collared shirt. If they come in looking presentable, like they're going to a church event or to a job interview, that's a good sign of a client that's going to be presentable in court. But if the client shows up, disheveled, not looking very presentable, that might be a red flag that you want to note. And again, not necessarily cut the representation from the beginning, but to try to coach them saying, well, it's okay to show up in, what you're wearing today, but going forward for future meetings, we need to start practice like we're going to court. We need to come here with a tie, a collared shirt, dress shoes, and whatever the equivalent might be for a lady. Because, every time you come to a legal office, I want us to be acting like we're in court or preparing for court and getting ready for game day. When you practice for football, be it football, soccer, or American football, they show up to practice wearing their uniforms. They don't show up wearing flip-flops and shorts and sandals. So I try to get people to learn that when you go to court, there's a uniform. The uniform's a tie, jacket if you're a man, a dress if you're a lady, and you should practice that through meetings with me at the office, how you get ready, how you present. Because for some of our clients, they're not used to getting dressed up for court. But it's something that they have to learn, I think, to present the best case or, from the initial impression when you walk into the courtroom, you want to make sure that initial impression when the judge sees your outfits or your clothes, that you look good. If your staff are disrespectful, if your prospective clients are disrespectful to you or to your staff from the first meeting, that's also a big problem. If they're upset with you about your parking situation at your office, if they think your office was difficult to find and they're complaining to you about those little things at the first meeting, that's a big red flag. If they're upset with you about little things, about having to wait maybe 15 minutes to meet with you, maybe you had were late from court or had some other issue you were dealing with and couldn't meet with them right at 1 o'clock in the afternoon, if they give you an earful about that, that might be a red flag. Because during the course of a case and litigation, there's always going to be good and bad news. No case is perfect. So if your client is upset and all up in a hussy about you showing up 15 minutes late to a meeting, imagine what that client's going to be like when you get a bad result in court. Now, when I say bad result, it might have been a good result from your end that you put in 100% effort, you did everything you could, but the law is the law, judges are judges. You're not going to win all your battles. So if clients are fighting over little things like that, that's just going to be a problem that you're going to have to deal with down the road. And it's best not to have that problem by not even taking on the case. My favorite example of professionalism is not being invested in your case. I love it when MVLS clients come because 90% of the time they come prepared. They come with all the MVLS documents. They come with all the pleadings that have been filed. They've saved all the pleadings, even if the other side is represented or not represented. They have the complaint. They have the answer. Sometimes they come in with discovery, interrogatories, requests for documents. Sometimes they even go further and start answering the document requests. They start answering interrogatories. To me, that is an awesome client and someone that you want to rope in because that's a good client that you want to have for life. But I have a lot of, in both my private and also pro bono cases, sometimes it comes about where the client comes in and they don't have anything. They come in with an empty folder and the case has been going on for maybe 6 months, 8 months. I can see on case search that a lot of things have happened. There have been discovery exchanges, there have been filings, motions, but they come to your office with nothing. And you ask them, well, where are your documents? Do you have anything? Oh, I don't have it, or I threw it away, or I lost it. But what they're essentially telling you is they want you to go to the courthouse, pay 50 cents to make copies of all these different documents. And to me, that's an at-risk client. If a client comes in, they're not invested, they don't really have a lot of foundation laid for their case just on their own accord. Because sometimes clients will say, oh, well, I don't understand the request for documents. I don't understand what it was. Well, let's look at it. The first request for document is to produce 3 years of tax returns. What part of that can't you understand? The first interrogatory question is, where do you reside and who do you live with? Why is that so hard to understand? Again, these red flags are things that you should look for in the beginning, but you should always try to coach the client initially. Going forward, you have to save documents. Or if you don't have any documents, I want you to go to the courthouse. I want you to pay 50 cents per copy to get these documents from the court. Try to put the ball in their court, because you just don't want to be an instrument for your client, that you have to do everything from getting documents from the court to starting to do interrogatories from scratch. Try to put the ball in their court from the first meeting before you enter an appearance in a case. So if you have a trial that's coming up like in June, you get the MVLS placement now, you may tell the client at the first meeting, well, we're going to meet again in 2 weeks. In 2 weeks, I want you to go to the courthouse. I want you to get copies of these pleadings or these motions. I want you to, and this is how you do it. Here's a step-by-step instruction of how I want you to do it. You're going to go in, go past security, go to the family division. You're going to write down the file number. They're going to give you the file. You're going to make copies. And then with interrogatories, your request for documents, I want you to go through and start answering these. I tell them, it could be in bullet points. It can be in Spanish. It can be in whatever language you want to write it in. But I just want you to begin to start formulating the ideas, and then tell them to come back in 2 weeks and see if they've listened to your advice and to see if they've taken the steps to become invested in their case. Because if they don't, then that's kind of like the second straw, and you may not want to consider taking on a case where the client expects you to surrender everything else you're doing just to focus 100% on their case. Because you do have other work to do. You have other pro bono cases, judicial cases, other private clients. So, I treat a pro bono client like I would a private client. I expect them to take some initiative and become invested in their case as well. Another red flag from the initial consultation that you should look for is a client that won't let you speak. You sit down for the client for 30 minutes or an hour, and 90% of that conversation is them talking. And they're not giving you easy access to come in with advice, or when you try to give advice, they go back to whatever it is they were saying, which may not be relevant at all to what their case is about. You'll have some clients that come to you like you're a therapist, and they want you to listen about all their problems with the visitation exchanges, all their problems with their ex-boyfriend or ex-girlfriend or ex-spouse. And all that isn't really terribly relevant sometimes to a divorce or custody case. The fact that the kid doesn't have his favorite pair of pajamas at the father's house is not going to make or break a custody case. But for some clients, they're going to spend a lot of time talking about little things like that have no relevance really. But when you look at your watch, an hour-long consultation is almost over, and you haven't had a chance to go over maybe the 5 points you wanted to. And when you do speak, it goes in one ear and goes out the other. So you may say, listen, the fact that your boyfriend had an affair with somebody isn't going to have a lot of relevance perhaps with a custody case, because custody is looking at the best interest of the child. So he might have had an affair with another person, but he may still be a fit and proper person for visitation. And you may say that, but then they keep on going with the same point, that just because he has another girlfriend that he lives with, the child can't go over there. And you could spend hours reminding that person of that advice, but it may not have any, goes in one ear, goes out the other, it has no bearing. Sometimes clients are too emotional, and that can be a red flag. I understand when you're going through a divorce or a custody case or an immigration case or a criminal case, there are initially some emotions you have to deal with. And maybe at the first consultation, you give some leeway for those emotions to play out. But if that continues into the second, third, and fourth consultations, it's a bigger problem, a problem that they may want to seek therapy for, or some other professional help that is not legal help. They may have to seek mental health treatment. But you want to make sure that if clients are not willing to take control of their emotions and to seek help, that can be a red flag. And again, my last point, honesty. You have to be honest. So if clients are telling you multiple stories each time you meet with them, if they're showing you documents that have been altered, sometimes clients want to alter tax returns to reduce their income. All of this will come back to haunt you down the road. And ultimately, as an attorney, the buck always stops with you. When you put your name on a piece of paper saying, I represent Jose Canto in this case, you're sort of vouching for that client that they're going to do things the right way. They're going to do things honestly. And if you are sort of vouching for them and in court, all this comes out that they're lying about something, if they're not being truthful, if they're making false documents, that's all going to ultimately be hurting your reputation and your status as an attorney. So like I said, the microcosm is your office. What happens in your office is just going to be magnified when you get to a deposition, when you get to court. So try to control these issues early on. Try to coach clients to improve and to be better and to overcome some of these shortcomings. But if there's no way, no option, no hope that they're going to improve at the second or third meetings, then I would not take on the case. And you would want to withdraw from that case. And there's ways to do it. I think we'll talk more about this later, but when you have a problem client, MVLS has a number of staff people that are willing to help you sort of withdraw from a case. And there's two ways to do it. You can do it, before anything's filed in court or before your appearance is entered in court. And that just requires a letter to the client kind of explaining the situation. But if you're in court, there's a very specific procedure you must follow according to the Maryland rules to withdraw from a case. There has to be notice to the client in writing. I believe it's 5 days before. Then it has to pretty much tell them that when the next court date is, how they should go about retaining new counsel or entering an appearance pro se or in proper person, and also including the address for the court where they can file a pro se appearance. And then you have to, pretty much explain why you want to withdraw from the case. You don't want to go into too much detail because there's attorney-client privilege issues. But generally what most attorneys say is there are differences, irreconcilable differences. That's sort of the magic catch-all word that I see attorneys use and that I use. That pretty much is the wink to the judge saying something has happened in the case. I can't go on. I need to get out. And usually just by saying those two magic words, you will generally get out of the case. But you don't want to go into, I'm withdrawing because my client gave me a fake tax return. You don't want to be that specific because that would actually prejudice your client. And they're still your client until you finally get out of the case.
Jose, if I could jump in for a minute. I would say, like you said, majority of the cases that the client is very eager to work with a volunteer and there's not any issues that come up, but sometimes there are. But one thing I would just say is that if you're a volunteer and you're working with a client, and issues arise, whatever they may be, the client's not calling me back, or I don't feel that they're listening to me, or whatever the situation that especially newer volunteers, but really all volunteers would try to reach out to MVLS as quickly as possible and make use of, our paralegals and our attorneys who might be able to kind of coach you through what to do in this situation. Because a lot of times, the client is not familiar with working with an attorney. They're not familiar with what the expectations are. Like you had kind of mentioned, how do you dress in court? They may not be familiar with that. They're not familiar with business hours are 9 to 5 generally, although, that might seem obvious to all of us. Maybe it's not as obvious to them, like, please don't call me all day every Sunday or something like that. And so things like this do come up, and we, our first course of action is usually to try to work with the attorney and the client to see if we can come to some kind of a resolution, because sometimes it really is just an issue of communication, and what the expectations are. And that's kind of the gist of this whole presentation. Yes, there are situations where there's irreconcilable differences, and that happens sometimes. But a lot of it also, sometimes we are able to kind of impress upon the client what the expectations are and things like that, so that things do get off to a better start the second time around. So anyway, all that is to say that if anyone, is experiencing any of these issues, please contact us sooner rather than later. The longer you usually wait to contact MVLS about a problem with a client, the more time goes by and the more the problem tends to build, and it does get to a point where it is unsolvable at some point in time.
Yeah, and as Ms. Henn was saying, I think most clients are open to coaching. They want to improve, they want to learn, they want to win. That's kind of my I guess bottom line. Clients want to win their case, but they have to understand what the rules are. You don't just go out to a soccer field and just start kicking around the ball. You have to know that there are some rules of the game, and clients will generally learn those rules if you coach them. They'll learn that, I have to be honest, I have to listen, I have to be professional. In addition to many other rules during the course of a case, rules about discovery and rules about how to answer questions. There's a lot of other seminars that we can do just on those different parts of coaching clients. But I guess what I'm talking about, there are certain red flags at the beginning that may be long-term problems that the client has, issues of honesty, issues of listening, issues of professionalism. And these are things that you want to kind of resolve right at the beginning. And like I said, this is kind of the rare situation. I would say, like I was saying earlier, very rarely have I had problems with clients where I would have to withdraw or I would have to call MVLS. But when problems do arise, you want to try to resolve the problem, kind of contain the cancer early, cure it, so it doesn't spread to other parts of the body or parts of the case.
Totally echo that. Yeah, and just like if you feel like you need help from MVLS to try to cure the problem early, don't hesitate to reach out to us.
Yeah, I'm ready for the next slide when.
All right.
Yeah, so for most of you on this webinar today, you're going to be taking on custody cases. That's a big part of what MVLS does. And once you get beyond kind of these initial kind of core themes of professionalism, listening, honesty, then you want to look into your client's case and to see what the facts are and to see what the outcome will likely be. And what's beautiful about custody cases, more so than maybe criminal cases or asylum cases, you can kind of predict the outcome based upon looking at the history of the case. And now this isn't 100% certainty. This isn't like a 99%. In life, there's always room for error or room for change. But there's a federal building here in Washington. I think it's the National Archives, and it's chiseled on one of the walls that the past is prologue. And I think usually in closing arguments a lot with custody cases, I mention this kind of creative phrase. I think it's from Latin, and I just know the English version. But when you look at a custody case, when a client comes into your office at the first meeting and they tell you pretty much from the birth of the child, from the moment the child was born, the child has lived with me and the father's seen him maybe 2 or 3 times per year since then. When a client tells you that, and the child at this point might be 6 or 7 years old, but when a client tells you that, you can pretty much tell the client with near certainty that she's going to be awarded primary custody of that child. It's just the way the courts are. They're going to look to the history from birth until whenever the case gets to the trial, and they want to see what has each parent been doing in the child's life. So conversely, when the mother comes with that type of story and tells me that, I'm like, okay, well, I feel confident we'll get you primary physical custody, and that has implications for child support. We'll get the maximum award most likely based upon a primary custody calculation. Now, if that same father comes to me and tells me the same set of facts and says, I've only seen my son 2 or 3 times per year, usually most clients will sometimes blame the mother. It seems to be their gut reaction. I haven't seen the child 2 to 3 times. I only see the child 2 to 3 times per year because the mother won't let me. I say, well, do you have text messages? Have you requested it in writing? No, I haven't. Have you gone to the school to try to see your son when he does his soccer games on Wednesday afternoons? No, I don't go to the games. Have you sent emails to the school or sent emails to the coach or sent emails to the church, sent emails to the doctors to try to get more involved? Oh, no, I haven't done that. I mean, when a client comes in like that, you pretty much tell them, well, unless you start changing your modus operandi here, she's going to win the primary physical custody. I mean, we're fighting over maybe visitation here based upon the history. You've only seen your son maybe 2 or 3 times per year, but you have to accept the fact that the history is not in your favor. You haven't really been involved in your son's life. Now, you can blame the mother as much as you want for your denial of visitation, but ultimately you also haven't tried also. You just have to accept that fact and try to improve starting today to try to get more involved. But when you have clients that have had very minimal to no contact with their child or their children, that's going to be a case where they're not going to be winning shared physical custody or primary physical custody. They're looking at visitation in that type of case. So I always ask my clients these questions, where does the child physically reside? How is that child doing socially, emotionally, academically? And what is the visitation schedule like today? How's it going? Is it going well? Is the child crying every night when he's with you? Does the child like spending nights in your house if you're the father? And if they don't, why? If they don't like spending nights with you because you don't really have a room for them, maybe you should consider getting a bigger apartment or creating a better space for the child so he wants to spend time with you more. But when you look at physical custody issues, you got to look at the past. And some clients don't want to look at the past. And the past may also have ugly facts too. If there's Child Protective Services involvement against your client and there was a finding of abuse, you have to tell your client you're not going to get unsupervised visitation. You're going to be looking at supervised visitation based upon what's happened in the recent history. Or if the client has an alcohol or drug problem and haven't been doing treatments or haven't been demonstrating they've been trying to control a substance abuse issue, they're not going to be getting unsupervised visitation. Now, of course, this is an opportunity for coaching. You can tell the client, well, you haven't been involved with your child's life with school or sports or with the church, but you can start getting involved starting today. You may not have asked for visitation, but I want you to start texting the mother, every week from now until the case, asking for more time, asking for more visitation, and let's wait and see their response. Maybe they'll say yes. And if they say no, there's a piece of evidence we can use in court to better improve your case. But still, even in spite of that coaching, you're only looking at maybe about 6 months to a year to show growth or to show improvement. And for a lot of judges, that may not be enough time to show a consistent, consistent behavior, consistent progress, especially if the child is older and the history has largely been non-involvement or not very much involvement. Also, sometimes the past might be good for your client. If a client comes in and says, I've been having 4 overnights a week since the birth of the child, or I've had 3 overnights per week and the mother's had 4 overnights or the father's had 4 overnights, that is a long history perhaps of a shared physical custody arrangement. And that might be what the judge will ultimately continue with as long as the child is doing well socially, emotionally, academically. The focus is always the child, and the judge is not going to be putting the child in a situation that's kind of new or revolutionary or that's going to change the child's life. So going back to that first example, if the mother has been caring for the child since birth and there's only been maybe 2 or 3 visitations a year, a judge is not going to go to the radical side of things and say, well, I'm going to have a shared physical custody arrangement here, or I'm going to give primary physical custody to the father. I've never seen a judge go off the deep end when the facts are like that and the child is doing well and the mother's been the primary caregiver. So you can't really change the history, so you can try to ameliorate the history, try to change the history a little bit, but ultimately the judge will look at the past, and the past is prologue for these cases. And same thing is true with legal custody. Who's been the one making decisions? Who's the one going to the doctor? Who's the one going to the dentist? Who's the one going to the schools? Who's the one dealing with the teachers at these parent-teacher conferences? Who's the one dealing with the rabbi or the priest or the pastor at the church or the synagogue? There's a history there, and someone has that history. Sometimes it's the mother, sometimes it's the father, but when you get a case, sometimes you have a very limited window to try to change things. You may only have 6 months to a year, like I'm saying, or you might even have less time. You might have a month or 2 months before your trial date to try to show a different history. But the judge will go back to birth until whenever the trial is, and if that history is in favor of your client or in favor of the opposing party, you have to deal with that reality and tell your client that the past is prologue in these cases, and we can't go back and change the past. And when you're looking at issues of physical, legal custody, judges are going to look to the history as being the indicator of what the future will be like. And that's how they're often going to craft their decisions. Same thing with child support. The tax returns are the tax returns. Whatever you made last year is what you made. You can't change that. So if you made a lot of money, a lot of overtime last year, a lot of extra hours, and you made $80,000 a year, that's the number the judge is going to use for child support. They're not going to use what you think you're going to be making in 2020 or in the future. So the past is prologue with child support also. Child care receipts, whatever the person's paying for child care is what it is. They've been paying it. Sometimes they have receipts, sometimes they don't. But sometimes they'll call the babysitter as a witness. They have been the child care provider taking care of this child because the mother or father is working. It's a necessary expense. I need to do it because I have to work. And that's going to be what the number is going to be. So with custody cases, my point is that there's not a lot of surprises. Now, there could be surprises. For example, one of the parents gets arrested, or there's child abuse or child neglect, and that happens during the course of a case. That could be a game changer one way or another. But in the majority of my MVLS cases, it's pretty much the history is the history, and the history oftentimes is a positive one for the child. The child is generally doing well with how things have been going in the past, and generally the judge is going to rubber stamp the past as long as the child is doing well. And I mention this because when you have your first consultations with clients, you want to tell them basically what I'm telling you now, that the past is prologue, and that there might be some room to fight for little things. Maybe we can fight for joint legal custody, even though you haven't been involved that much in the child's decisions. Maybe we can fight for more visitation, maybe over the summers, or have a consistent weekend schedule. Maybe we can fight for a downward deviation from the child support to reduce it a little bit. But these are all kind of wishful thinking tactics. Now, you really can't guarantee these things. What you can only guarantee is that the history, as long as the history is positive, that's pretty much how the judge is going to go going forward. So I don't make any big promises with my clients. When they come in and they tell me the history, I'm very sincere and very real about what the outcome will be. Because as we'll see in a later slide, most judges take a very conservative, centrist approach to these cases. They're not going to do anything radical or revolutionary, absent something radical or something unique in the case that comes up, which happens in a very rare sort of cases. So if a client comes into my office and says, I want shared physical custody, I want sole legal custody, and they don't have the history, I pretty much tell them it's wishful thinking and they should go somewhere else, because I'm not going to be able to deliver. I'm not going to be able to take a child away from a mother that's been with her for 6 or 7 years of his life, that's doing well academically, doing well socially, doing well emotionally. The judge is not going to change that absent something really drastic. Oh, well, the mother's a liar, the mother uses drugs, blah, blah. But where's the evidence of that? And most times clients don't have the evidence, and then they get upset with you because you're telling them the truth about the situation, but they're not willing to believe it, or they're not willing to see the truth. And that can be a problem. Some clients will never see the truth. They have their own reality of things. And no matter what you tell them or what advice you can give them based upon your experience with other judges or with the same judge or with these types of cases, they're never going to listen. And that's another red flag, going to listening, going to honesty, kind of those other two pillars I mentioned of the three. If they're not checking those boxes when you look at sort of the case, that's a big problem that you want to try to overcome. Well, I'm ready for the next slide.
Next slide. Okay.
When ready. Yeah, so this kind of goes to another saying I love in Spanish. So my dad used to tell me a lot. And this also applies with the custody case I just mentioned. And also, let's go to divorces now. We'll talk about divorces. Pero no hay peor ciego que el que no puede ver. So there's no worse blind person than the one that doesn't want to see. So kind of going back to those examples earlier, when people don't want to see the reality, they don't want to see what the situation will be like in court, and they're not amenable to that, they're not willing to kind of change the strategy based upon that, that's the worst blind person. That's the worst blind man. The worst person is not the man that's actually blind physically, but the person that can see but refuses to see. So in addition to custody cases and divorce cases, we have the same problem. Sometimes clients come in with a divorce and they can't get over the adultery that happened. They can't get over that the person wants to leave them. And they want to go after them for adultery. They want to go after them for cruelty of treatment and all these different grounds that, in my experience, are not really, among judges. Judges are not looking for a fault-based divorce. Almost 99% of the time with judges, they're looking for the 12-month separation, a no-fault ground. And that's pretty much how the divorce will happen. At the end of the case, as long as you have the 12-month separation, a judge will always, I think, take a no-fault ground over a fault ground. I'm not sure why that's the case, but that's just been my experience. They just want to always take a neutral, centrist, middle ground approach. They don't want to create a lot of hoopla over an adultery finding or cruelty of treatment. And some clients will come in with domestic violence. Sometimes they'll come in saying they've been mentally abused or physically abused. Sometimes they're lacking evidence, though, of these things. Sometimes they say that there's another girlfriend in the picture, the person's had another lover or whatever, but they don't have any evidence, but they want to spend all the time with you talking about a fault-based ground. I had one client that actually fired me because I wouldn't pursue an adultery claim. I said we could plead it. We're going to put it into your pleadings just to maybe facilitate settlement, maybe scare the other side a little bit, but I'm not going to go into the courthouse, spend all this money on private investigators and go through all these Facebook messages just to win on an adultery claim that really has no bearing. When you have a 12-month separation, like why spend a lot of time building a case, spending a lot of money on private investigators and all this, when ultimately it's not going to have that big of an effect on the case. And I've had even judges tell me in settlement conferences, listen, I'm not going to get all up in a hussy about an adultery claim. You can say that, the person has a boyfriend or a girlfriend and they've cheated on you, but I'm not going to really consider that in a large way. I'm not going to put a lot of weight in that. I'm not going to, I'll consider other things, but not adultery. So you want to tell clients in the beginning, there's sort of a disinterest I'm seeing in fault-based divorces. So do we plead it? Yes. Do we mention it? Yes. Does it have some bearing on your divorce? It does. But we shouldn't put all of our eggs in one basket. Why spend all this time on a private investigator to find out which hotel he's having an affair with? And maybe we never find that information. Maybe it's impossible to prove. Well, we could use that same money or that same energy to do a better job with discovery, or maybe take a deposition, or maybe subpoena a bank for bank records and pay the fees for copying that the bank's going to charge us, instead of spending money on private investigators and things that aren't going to make that big of a difference in a case. I always tell clients, a divorce case, you can spend millions of dollars on a divorce case. But in this case, we're dealing with pro bono clients, judicare clients. There's a litigation fund that gives us some money, but we have to be prudent in how we spend our money and spend our time. There is some restrictions on how we can prepare for a case. So we want to focus our energy on what really matters, which is usually money, which is usually property, which is usually the children, and not spend a lot of time, I think, on the reasons why the divorce fell apart and proving adultery, proving that, I was psychologically harassed and psychologically abused. Those things should be mentioned, but they shouldn't be the central part of your case. But for some clients, they're going to want to make that the central part of your case. Another issue is alimony. You've got to tell your client from the first meeting, it's an uphill battle in today's world. For most of my clients, especially with very short marriages that where both sides make the same amount of money or make similar amounts of money, pretty much it's a non-starter. There's no alimony to really be given. And if you want to get alimony, like rehabilitative alimony, you have to have a plan. You have to say, I want to go back to school. I want to do X, Y, and Z to enhance my career. But there has to be a plan. Alimony is not just like a lottery ticket that you get every month. With rehabilitative alimony, you have to show that there's a plan of rehabilitation to get you back into the workforce, get you back into school. And some clients just aren't prepared to come up with that plan. They just want the check every month and nothing more. Now, there's permanent alimony, which is even harder to get. And that's only kind of reserved for what I would consider your classic case of the stay-at-home wife that sacrificed her career to support the family. Usually there are a number of kids that are born of the relationship. The wife is the stay-at-home mom. The husband was the one working, or it could be reversed. It could be the husband that stayed at home, taking care of the kids, and the wife working. But ultimately, it's been a long marriage, maybe 20 or 30 plus years, great disparity in income. One person made sacrifices for the family, pretty much was paid to be the mother, to be the father, the stay-at-home dad, or the stay-at-home mom. And essentially, they are now getting divorced. So all this kind of free labor, all of this family labor that they put in, that's going to have no market value. So there has to be some alimony to kind of adjust the equities there. But that's kind of a rare type of case that most of your MVLS clients will not maybe be in. Most of my MVLS clients are people that come in, oh, I've been married for 2 years, but I want alimony. I pretty much tell clients that's not going to happen. I don't see that happening with any of the judges that I'm up against. You have to pretty much show, there has to be a longer marriage. There has to be some children involved. There has to be some sacrifice on your behalf. I was a stay-at-home mom, a stay-at-home dad. I took these decisions based upon my marriage, and I suffered now financially because of those decisions. But there also has to be a plan in place for going back to work, going back to school, doing more training. And for some clients, they're not willing to put in that type of thought process or that work to make that case. So I would tell clients, we'll fight for it, we'll try, but I don't think you're going to get it. And I would be very honest with them from the beginning, just like with the fault-based divorces. We're going to ask for adultery, but we're probably not going to get it. We're going to ask for alimony, but we're not going to get it. We're going to do everything we can to prove it, but it's just we're dealing with certain realities here that we have to live with. Marital property is another thing. Oh, I have $200,000 in my IRA, my retirement assets, but I don't want my wife to touch a penny of that. Well, I ask, well, when did you open the IRA account? Well, I opened it after we got married. I'm pretty much going to tell the client, listen, you're going to be giving up half of that to your wife. That's just, we're in a state here in Maryland where it's equitable. It could be 60-40. It could be 30-70, but generally judges go right down the 9-207 and the property is split, 50-50 absent a prenuptial or absent, you can prove it was non-marital, but all marital property is going to be a 50-50 split. All but, she's a liar. She has another boyfriend, but you can say all those things, but I don't see judges being swayed a lot by those arguments. They're going to say, well, one side might have had an affair, but there might have been something that you've done that was also bad. So they kind of cast blame equally when it comes to divorce, and they're not going to really find for one side versus the other. And it's showing, in my experience, going to be a 50-50 split down the road. Rights to pensions and retirement accounts, that's going to be through quadros, and that's going to be a 50-50 split subject to the Bangs formula, which factors in how many years they were married versus how many years they were working. Another issue is attorney's fees. A lot of clients come into your office, I want to make sure, I get paid or, you get reimbursed for your time. And I always say, well, I never have really seen attorney's fees ever be granted. Maybe 2 or 3 times in my career, I've seen a judge give me attorney's fees for very egregious conduct from the other side. In one case, the other side falsified a tax return, and it was obvious that he did so. In another case, the other side had started the case and was very aggressive on paper, but then didn't show up to court. And there was also really severe issues of domestic violence, and there was convictions for rape against my client. So there was a lot of unusual facts, a lot of unique facts that made attorney's fees sort of relevant and justified in those types of cases. But generally, for your most typical cases, you're not going to get attorney's fees, so you shouldn't tell clients that they're going to get attorney's fees. It's the exception, not the rule. And judges generally always will take a middle ground position on most issues. There's no winner-take-all mentality. So you have to approach cases with clients saying that the judge is always going to be looking for the compromise position, the 50-50 position that's in the middle. So you're going to win some things, but you're going to lose other things. And that's just the way most judges operate. And it's something you just have to prepare for and prepare your client for. But you want your clients to see the reality, to understand the way things are, and to not be that blind man or that blind woman that refuses to see. You want to be able to have them see the future based upon your experience and your intuition. And that's what they're paying you for, why they're coming to you versus other people, that you can actually give concrete advice based upon experiences, based upon your past cases, based upon your intuition you've developed by going to court, going to trials. And you have to communicate that to them early on to try to get them on board with the plan. And for a lot of my cases, what I'll do is I'll put it in writing. After they meet with me a couple of times, I'll say, this is my professional opinion about what's going to happen in your case. This is what I think I can do for you. These are the results I can obtain for you based upon my experience. But this is the most I can do based upon how I view the world and view the legal system. And if clients can't subscribe to that view, it's a problem. because if they're wishing for a lot of other things that you can't deliver, that's just going to create problems for you down the road. And bar complaints, them complaining to you all the time and not being happy with the result. And ultimately, you want your clients to be happy with the result you can provide based upon the past and based upon the way judges and the courts operate, based upon your experience. Yes, you can ask for attorney's fees. Yes, you can ask for fault-based divorces. It's in the code. It's in the statutes. But judges may not be willing to give you those types of rights or those types of benefits in reality, in day-to-day practice. So I'm ready for the next slide.
Yeah, and I think that's a really good point, and something that, I know I've talked to other volunteers about is if you feel like, you've advised a client of what's likely to happen and that maybe they're not hearing or listening, that putting it in a letter to them in writing is definitely a good idea.
It doesn't have to be a very long letter. It could be very short, but I would just pretty much say with that first custody case I mentioned, if a woman comes to you and says, or if it's the father of the child that has only seen the child 2 or 3 times per year, I would tell that client, listen, I'll fight for a visitation schedule. I think we can share holidays, get you on a alternate weekend type of schedule, Saturday to Sunday overnights. We'll fight for joint legal custody. It's probably going to be tiebreaker to mother, and you're going to be paying child support. If you made $80,000 last year, that's going to be your income. Here's her income that she says she makes, or based on her records. Here's a copy of the guidelines. This is what you're going to be paying, and take it or leave it. That's pretty much the way the case is going to go. We'll fight for little things. We'll fight for maybe a credit for past payments of child support. We'll fight for maybe more time over the summers when the child's not in school. But this is pretty much how the case is going to go based upon my experience. And with divorce cases, if they come in with all this property that was marital, it's a 50-50 split. That's the way it's going to be. If you can't agree on how to deal with the house, it's going to be sold, 50-50 split after all the costs. Retirement accounts, 50-50 as well. If it's a pension, it'll be subject to the quadro, but that's going to go out the door. And just maybe give bullet points as to where you think the case will go. And that's your official opinion on the case. So then down the road, if they're upset with you, I didn't know I couldn't get this. I didn't know this was going to be that hard of a fight. I thought it would be much easier. You can say, well, from the very beginning, I told you this. And you still continue with me, knowing that that's how the case is going to turn out. So you can't be upset with me now, because that's what I promised to deliver. That's what I delivered. Maybe we won on certain things that I told you were going to be risky or not going to be guaranteed. We tried, we gave our best shot, but that's just life in the big city. Same thing is true with parts of, going to discovery. Like I said, you could have $1 million custody case or divorce case if you wanted to. For depositions, for example, I could tell a client, it's my professional opinion that we should maybe do a deposition of this witness or do a deposition of this opposing party, but it's going to be expensive. The litigation fund will only give me so much money for it. They're not going to cover everything. If you want to pay for it, you can if you have the resources, but I suspect you don't, because you're in the situation financially. You're receiving pro bono judicare services because of your income. But I just want to let you know this was a possibility that we can't explore because of expenses, but it's just a fact of life we have to accept. Expert witnesses could be expensive. If you need expert witnesses for valuations of businesses, you can tell the client, listen, your ex-partner has a business. We should do a forensic evaluation of the company or hire a forensic accountant to look into the business to give a value for the business. But we can't afford $3,000 for an accountant. But it's something that we should do, or we should consider doing. But there are some realities of cost here that we have to deal with. Now, there are ways to ask the opposing side to pay for it in those types of cases. You can file a motion to ask for attorney's fees up front or to have expenses paid by the other side. So there's steps you should take, but you should at least keep your client informed these options are on the table. So when they come back to you later on, I didn't know we could take a deposition of this witness. I'm like, well, I wrote you a letter saying that we could have done it, but I needed money to cover the transcripts, the stenographer, to do the deposition, and we just didn't have the money to do it. You couldn't pay for it. The litigation fund couldn't pay for it. I couldn't pay for it. So it was sort of, we had to accept that reality. But it's really important that clients are informed of decisions like that throughout the case, especially pro bono judiciary case, because there is a cost factor that we have to consider that might be high, that you may not be able to afford, and your client can't afford, or the litigation fund can't afford either.
Yeah, absolutely. That is a challenge with the judicare case.
Yeah, so the next slide, please.
Sure.
And I believe this is the one about communication, correct? Unfortunately, my computer fell asleep on me. I'm trying to bring up.
Oh, okay, yeah. Yes, this slide is there will be business enough. Honest Abe never got to be selective in your clients.
Yeah, so I know a lot of you are saying that, if I'm too selective with clients, if I raise them to these standards of professionalism, honesty, listening, I may not be able to have a lot of clients. I don't want to turn away business. If someone comes to you that might be difficult, that may present these things, you're up against the question, well, I can either turn away this client, but then I'm turning away business. I'm turning away the judicare funding, which is pretty generous. It's $100 per hour up to, I think, $3,000 of a total payment. And you're, considering your business and your payroll and other expenses you have. So you may be at a loss, should I just take the risk and, take this case knowing that it's going to be problematic, knowing it's going to be difficult, or should I just let it go? And Abraham Lincoln gave a lecture to law students many years ago, and it's online. But a lot of great advice, a lot of great wisdom in that speech. But one thing he mentions in there is that there will always be business enough. You can be selective with your clients, you can be selective with your cases, and there will always be people rapping on your door, knocking on your door for business, be it judicare cases, pro bono cases, private cases. So there's no need to take a case that you feel uncomfortable about. And over time, you develop a gut for these cases. I know I've developed a gut for these cases as they come in. I just feel after the consultation, after a couple consultations, that there's no hope here. It's going to be a difficult case for me to work with. It is a very close relationship, that between an attorney and a client. It's a very personal one. There's a lot of long meetings together, a lot of phone calls together, a lot of time spent together. And if you're not comfortable working with that person and you can't work as a team and there's trust issues, it's just going to be difficult. It's going to be one of those cases that are going to be like, stones in your shoe that you're always going to feel every day when you walk around. And you don't want to have that. It's just going to lead to more stress. So I would encourage you to hold your clients, going back to the first slide, to very high ideals, very high standards, just like you're held up against, so that clients know what the rules are, know what the values are in your office, and to make sure that they respect that. And if they don't respect it, it's better to let that case go than to keep it.
Let's see. And then, Jose, I think the next slides are on to my slides.
Oh, sure.
And I don't mean to interrupt. Anything else you wanted to add before I jumped in?
Oh, no, those are my points. And I think, like I said, we're talking about the exceptional cases, not the normal cases. For most of you, you'll have wonderful experiences with MVLS and their clients. They go through a vetting process themselves. So by the time you get the final product of a case that's ready to go, generally they've been through intakes, they've been through screening, and they've dealt with MVLS, they've dealt with the staff there. So you're getting generally good clients, but my only point is to be careful with clients that present some of these red flags, and establish rules for your office too with phone calls. I know that's been a gripe of a lot of people. All clients are calling me 24 hours a day. I don't have any time. Establish rules. Like here in my office, for example, if your issue takes more than 2 minutes to resolve on the phone, you have to come by for a meeting. So I don't mind doing a phone call, confirm a court date, or talk about upcoming events that I can do in 2 minutes. But if they want to talk about what happened last weekend, if they want to talk about discovery, if they want to talk about the trial and the testimony, you have to come by to my office. So you can kind of control the rhythm of your practice by making people come to your office for a meeting, because that puts pressure on them to drive to your office, to park, to walk in, to carve out time of their day. They're not just sitting, in their car calling you, going on for an hour about what happened last week in visitation. which may not be relevant or important at all, but you're on the phone, you're stuck talking with them, it might be hard to get off the call in a respectful way. So try to control that by having rules like if it's going to take more than 2 minutes to tell me something on the phone, you have to come by for a meeting. And then if people call you nonstop, having a secretary helps. They can be your first line of defense against abusive clients. But I would just tell your clients, listen, I can't take all these phone calls. Your case is very important to me. I'm working very hard on your case, but I can't be distracted by all these little phone calls throughout the day. And you can always do that by text message or by email. If you get 30 phone calls in one day from a client, maybe it's not best to call that person back because they're going to chew off your ear for an hour. It might be best to respond with an email or a text asking them to, either answering their question or answering their concern or inviting them to come to your office for a meeting, to put pressure on them to carve out time to actually come to see you physically in person to avoid you spending hours on the phone, because people will abuse phone and text message all day. And it's very easy to do. You can be at the gym on the treadmill and talk to your lawyer about whatever it is. And they're doing something productive, but you're not. You're stuck at the office talking to this person. You may have a lot of people waiting to talk to you in your lobby, but because this person's on the phone when they're driving in their car 3 hours to work or wherever, they can really abuse that privilege. But you still have to respond to clients to avoid ethical problems. But you want to try to control that with maybe text messages or emails to kind of put the parameters or the game in your court, and you can control your schedule and control your time better that way.
I think that's a really good point, and I think that's actually like a pretty common complaint that we get regarding MVLS cases, is that a client might be calling and texting very frequently on nights and weekends, and how do I deal with that? So that thank you for sharing those strategies. That was something that I was going to kind of pose as a question to you. So I have a couple slides that I'm going to go through fairly quickly because we are right past 1 o'clock, I think. But I do want to invite the audience while I'm saying the last couple words to type in any questions that you might have to the question box or the chat box if you do have them, and then we will make sure to pose those to our presenter when I'm finished going through these slides in a couple minutes. But just kind of wanted to touch base on what are some of the common challenges in MVLS cases that I see when volunteers do call our office or clients call our office. One of them is just, make sure you're very clear on the scope of your representation with the client. Oftentimes clients call us on intake and they have 3 or 4 legal issues, maybe more. And we are, because of MVLS's guidelines and what we're able to help with pro bono, we tell them, for instance, we can take on your custody case, but we can't take on your protective order case. That's one of the things we typically don't take on. So you as the attorney should also be very clear with them in your representation agreement and in your first meeting about what it is you're representing them on and what you're not representing them on, because our clients do often have a lot going on in their lives. And sometimes they think, you're their lawyer, you're going to help them with whatever legal issues are going on. So just, it is very clear to kind of set that, very important to make that clear at the outset. The other thing is and I think Jose touched on this quite a bit, the client wishes to pursue unrealistic goals. That's something that comes up. This client thinks they have a custody case and they are very likely to, get full custody and the other parent get no access whatsoever. That is, often not a realistic goal. And so one of the things that we sometimes get complaints about, I guess, from clients or volunteers is, my volunteer didn't achieve what it was I thought that I could achieve. And so really some of the strategies Jose gave for sending out that letter at the beginning about what you've determined is likely a realistic outcome and having those conversations at the beginning are very important. One of the other things is this is kind of the opposite of the client who calls all the time. A client becomes unresponsive to an attorney attempts to contact them. And as Jose mentioned, that can be a red flag often, because that does mean they are less likely to show up for court or other important meetings that you might have. So in that circumstance, I would encourage you to please get in touch with MVLS as soon as possible. Don't wait. And this is kind of like into the next slide of what to do when a client issue arises. Do try to contact the client to talk it through, but if you can't get in touch with them, do please reach out to the MVLS paralegal who assigned you the case. And you also have my phone number and Sarah Witchery, our pro bono program manager, phone number on the screen. If you need to contact us, don't hesitate, because we like to get involved sooner rather than later, so that we can try to troubleshoot whatever it is that you're experiencing as a volunteer. So with that, I just want to say, thank you so much to Jose. Thank you to our audience for attending. We do have a number of ways you can follow MVLS on social media that are listed here on the screen. And even though many of us are remote right now, we are still doing our webinar trainings. We typically have several trainings a month, so we do encourage you to check out our website to see what upcoming trainings we have scheduled. That can be a great thing to do from home. If you are interested in taking on a case, I just want to highlight our pro bono portal on our website. You can see we're at the top of our website. This is what it looks like. You click pro bono portal, you'll see something that looks kind of like what's on your screen right now with the cases that are available to take on, and you can sort it by type of case. For instance, you're looking for a debt collection case, you can click debt collection and it'll sort for you. So once you see what a case you might be interested in, you can click learn more, and the paralegal who's responsible for that case will reach out to you with some more information. Trainings and volunteer opportunities. We have a couple trainings coming up. We have a guardianship training coming up on April 2nd. That'll be via webinar. And we have our next month's third Thursday training is about ground rent. So that should be an interesting one coming up on April 16th as well. And you can always register for those on our website. We also have a lot of recorded trainings available if you are interested in trainings on some of the other topics that MVLS cases typically are involved in, and they are listed on your screen, but you can go on our website and check out all of the different recorded trainings we have available. This training will be available as well. It is being recorded. Finally, if you're not currently a volunteer and you're interested in signing up to be a volunteer, this is our link to, which is available on our website to sign up to be a volunteer with us. So with that, let me see if I do show any questions right now. I don't think I do. So Jose, I just want to thank you again so much for being with us today, and for doing.
My pleasure. Thank you. Thank you for having me.
Yeah, it's very helpful to our new volunteers to kind of hear from someone who has some more experience. So I do appreciate that, and I look forward to some of you all in the audience joining us on the next webinar. Thanks, everybody.
Great. Thank you all so much. Take care.